Hey guys, Brent Boyer again. So let's talk divorce. And please like and subscribe to the channel. That'll help us out. So I wanted to talk today about a divorce initial meeting, initial consult with a divorce attorney, and how that goes and what's that like. We always get questions about how this is set up and the format and types of questions you ask and those sorts of things. So I wanted to run through that with you and do sort of a mock interview, initial consult with a divorce attorney today with you. So here's some facts, first of all, to keep in mind of what I'm looking at in discussing this hypothetical client's divorce. So let's say there's been they've been married for 20 years, they have 2 kids, 13 and 15, and they're still living together, and they're both in their mid-40s. Wife's 45, has a college degree or maybe just an associate's degree, and husband makes about $90,000 a year, wife makes about 40, and then we'll go forward that way. So the discussion usually is wherever the client starts, of course, is one place that we go, but beyond that, normally, first of all, we're talking about the children. That can be the most important topic. It's really the most important topic in a divorce. So we look at, okay, you got 2 teenage kids, you're living together for now, so how do you proceed? What's to be expected here as far as custody, parenting time, and child support during the divorce and once the divorce is completed? So what we're looking at, custody has really 2 parts to it. First of all, there's legal custody and physical custody. So I would normally assume you're going to share joint legal custody. That's typical in most counties in Michigan. It's typical of what we see every day. So you would share joint legal custody, and what that means is you share in decision making in the children's lives. So medical decisions, decisions about school, decisions about religion, anything important, a significant event, a significant decision to be made in the child's life would be done jointly, probably like it is now. That would continue after you're divorced. So legal custody, joint legal custody, has nothing to do with where the kids stay or where they live. It's all decision-making authority, legal rights of a parent, and what that looks like. So then the other part of custody is physical custody. So we would talk about, okay, so what does that look like? So who has physical custody? There's this label under Michigan law called sole physical custody. Sole meaning they live with one parent, or maybe you have shared physical custody. So shared physical custody is going to mean more than the typical just every other weekend type of stuff, but probably somewhere up to half the time with the children. So physical custody does get more into where do they live, what's their residence, where do they stay, how many overnights a year do you have with them. So physical custody intersects with parenting time. And basically the best way to talk about physical custody really is to look at what's the parenting time schedule, because really what counts is when do you have your children? So that's what you're looking at there. And going forward from there, custody and parenting time. And then at this point in the discussion, it's good to look at, okay, well, what's the living arrangements now? Where are we headed? Is the client planning on moving out? Is the wife talking about moving out? Is any of that going to change? Because if so, we want to talk about that. Living together is always the best strategy at the beginning of a divorce when you have kids, but it doesn't mean you have to stay together and drive each other crazy. If you're getting divorced, you probably don't want to keep living together. Michigan law does not require you to keep living together. It doesn't require you to live separate. It really takes no position on it. So at the beginning stages of a divorce, our advice is stay living together if you can when you have children. That way we know you're avoiding problems like when do you see your kids and my wife won't let me see my kids, or there's these issues with custody and parenting time. If you live separately, you start getting into child support issues. If you're living under the same roof, there could be no child support by definition. So that's one thing to keep in mind, and what goes hand in hand with that advice is filing first. There's advantages to filing the divorce first, and one of those advantages involves getting court orders signed at the beginning that can affect custody and parenting time. So your wife is threatening to move out or making plans to move out, she wants to take the kids, and you really don't want that, you don't think that's what's best for the kids, it would be possible, at least in theory, to file first, get a court order signed that gives you shared custody, and that would prevent your wife from removing the children from the house. Now I say in theory because not every judge is going to sign these court orders. Most of them will, some of them won't. They're called ex parte orders. They get signed without a hearing, without notice to the other party. And signing these ex parte orders, for example, like I said, giving a court order that gives you shared custody and prevents your wife from moving out and taking the children, that it can be very important. It can have a big impact on things. It gives you a little more control over the situation instead of your wife just making unilateral decisions and doing as she sees fit, maybe to the detriment of the children, certainly to your detriment. So we do like to have that discussion about the advice of living together, living apart, and what all that means. You can certainly do either one. If you're going to live apart, that's fine, but again, it goes back to the advice of then get a divorce filed first before you make plans to move out. Then you have a way to keep things under control. You have someone that has jurisdiction over it if there's disputes. So meaning now a judge can decide things if you two aren't on the same page and you're living elsewhere and you need custody, parenting time, support, whatever it is addressed by the court. And so that's one thing to look at there, living together, living apart. And if you're going to live apart, you could file first. It also allows you then to get a court order in place that says whatever the agreement is the two of you have. Maybe you have an agreement, but you just need to get something put in writing. If there's no lawsuit filed yet, there's no way to do an agreement and have anybody held to it. So then let's talk child support a little bit here. So you're living together for now. That means there's no child support. You're just paying your share of the bills. Your wife's paying her share of the bills, hopefully. If she's not, you get a divorce going and you can make sure that that's happening. So in our little scenario here, we've got a husband that makes $90,000 a year, a wife that makes $40,000 a year. There's 2 kids, 13 and 15. And let's say first scenario, there's going to be an agreement that wife will have custody of the children. Husband's just going to have parenting time. He's going to do reasonable parenting time every other weekend type of thing. So every other weekend, the way that that's going to look for parenting time is going to mean husband has 80 overnights per year. That's going to mean his parenting time, 80 nights a year, is basically an every other weekend schedule, a couple weeks in the summer, holidays, and vacation. So let's say he has that's minimum amount of time for parenting time. It's what some of the counties refer to as reasonable parenting time. So let's say we're doing reasonable parenting time for husband. He makes 90 a year, his wife makes 40. She's going to basically have physical custody of the children. If that's the case, his child support is then going to be $1,400 a month for 2 kids. So now he's paying $1,400 a month, probably not during the divorce, because normally during the divorce there's either a living arrangement or a status quo payment of bills or some hybrid number. Basically you're doing family support and handling things that way and not just straight out child support. Child support normally is contemplating you live separate households, you live separate lives, you're not paying any of each other's bills anymore. So the $1,400 a month really wouldn't start till the divorce is final and everybody's gone their separate ways. So that's one scenario. And you think, well, that sounds like a lot of money. Is there any other thing to look at here that's going to have that lower and also get me more time with my children? So there is. You can also do shared custody. So under our same scenario here, wife makes 40 a year, husband makes 90. Let's say we're doing shared custody. So all the way to the other extreme. Now husband has half the time with the children. Wife's going to have half the time. If that's the case, then the child support at that point is down to $400 a month for 2 children. So goes down $1,000 a month based on the number of overnights that you have in a year. So that's a big difference. So now we're in this range of my child support might be as low as $400 a month, could be as high as $1,400 a month. So the reality is probably going to come out somewhere in between. I'm probably not going to have exactly half the time with my children. I'm probably going to have more than reasonable parenting time, more than every other weekend. It's going to fall somewhere in between. So then the number I end up actually paying once we're divorced is going to be somewhere in between. And then if you're looking at shared custody, why the child support isn't 0. So the only time you're going to see a child support number come out to 0 with shared custody is if the parents have exactly the same income. So in our scenario here that I'm looking at, husband makes 90, wife makes 40. He's going to pay some child support even if he has half the time with his children. So then with the child support discussion, you're also looking at, okay, then what's my alimony, what's a spousal support obligation here? Because if you look back to the discussion we're having here, husband and wife have been married for 20 years. He makes 90, she makes 40. So there's a significant difference in income. It certainly is possible that there's going to be some alimony or spousal support. Michigan does, we definitely do alimony, spousal support. It certainly comes up in divorce cases and it's an issue. So there's no exact calculation of how to figure out spousal support or alimony. There's software that allows us to calculate some numbers. Nobody's bound by those numbers, but they're out there. So it really becomes kind of child support for adults is kind of how it's working. So if I'm in for $1,000 a month in child support, I could be in for another $500 in alimony, let's say. It could be whatever number. We'd have to know a lot more about the facts from this particular client to get into exact numbers of spousal support, but it certainly isn't zero based on someone making 90 and someone else making 40. Child support gets calculated first, the way Michigan law works. So we'd have to know what we're doing with custody and parenting time, get a child support number. Then we'd be open to looking at, okay, what's spousal support likely to be, what's a range. We could put some numbers on that and get a sense of what that all looks like. But then moving through what other questions the client is typically going to have here, doing a review of a divorce case at the very first meeting, at the initial meeting, there's also a discussion of the house. So they own a house together. They're still living together, married 20 years. So they probably bought the house during the marriage. So it's what Michigan would call marital property. So because keep in mind, Michigan has marital property and we have separate property. We're what's called a dual property state. So the house is probably marital property, meaning we bought it during the marriage with money from one of the two people during the marriage, and we've gone forward that way. So let's say in our example, the house is worth $250,000 and they have a mortgage of $200,000. So there's an equity of $50,000 here. It's worth $50,000. If they sold it, they could end up with right around $50,000, at least theoretically. There's closing costs and other things, but let's just say it's $50,000. So then you normally have kind of three options in a divorce case of what to do with your house here. You could keep it, your wife could keep it, or you could sell it. Those are typically your three choices. So one scenario would be you keep the house. If you're keeping the house, you would keep it, and your wife is going to be owed some money. So basically, under our scenario, there's $50,000 in equity. You owe half the equity, which is $25,000. Now, if it's a joint mortgage, you're probably going to want to refinance it, get her name off the mortgage, and then go forward that way. Now, a second way to look at the house, another option would be your wife keeps the house. So she makes $40,000 a year, but it sounds like she's also going to have some child support coming in. So can she qualify for $200,000 on a mortgage? Maybe. She'd have to look at what the options are there, but it might be possible also for your wife to keep the house. Under that scenario, she keeps the house. Now she owes you half of the $50,000. She owes you $25,000. So worth $250,000, we owe $200,000, $50,000 equity. She owes you half of that. She owes you $25,000. A third possibility when you're getting divorced with what to do with the house would be to sell it. So if you agree to sell it, you're going to do that. Whatever money you end up getting, you split equally, and you both walk away with your share of the proceeds from the sale of the home, around $50,000 minus closing costs and realtor fees and whatever else might be involved. So that's really what the discussion looks like with the house, other than questions about, well, do I live here? Do I move out? Does she move out? If we're going to sell it, when do we sell it? How does that look? So, sale of a home can happen before a divorce. It can happen during a divorce. It can happen after a divorce. As long as everybody's on the same page and you got agreements on things, all of that is totally fine. But you want to make sure you have, definitely have some agreements on things. So then, as we go through this initial interview, we're looking at what else is going on here. Let's say your wife is cheating on you, and that comes up. You bring that up. Well, she's cheating on me. How is that going to affect things? Do I need proof of the fact that she's seeing someone else? Do I need evidence? Do I need to give you the evidence? And what does all that look like? So, unfortunately, or fortunately, I guess, depending on how you look at it, the way Michigan law is, a cheating spouse is going to have very little impact on a divorce case. Whether it's custody, parenting time, division of property, spousal support, whatever the dispute in the divorce is, the fact that she has a boyfriend and was unfaithful is really going to have very little to no impact. So for the divorce attorney, we're sympathetic to it. Obviously, it's a terrible thing that someone has done, and we don't like it either. But to say that that's going to mean it gets you somewhere in court isn't going to be the case. There's a few reasons for that. First of all, Michigan's a no-fault state. So they're not looking at, in other words, you don't need a reason to get divorced. Because you don't need a reason to get divorced, the causes of divorce become sort of not that relevant to the divorce case. They're just not that relevant to the lawsuit. So Michigan is kind of no fault happy, no fault divorce, no fault auto, it's no fault everything, nothing's anybody's fault. Well, of course it is somebody's fault, but it's not going to lead to you getting more than your half of the property, or you getting a better deal on custody and parenting time, or getting a better outcome on spousal support or child support. It just doesn't affect those things at all. I mean, it's a 5% factor in the worst scenario you could think of. So it's a very diminished kind of thing in a divorce case. Really won't matter. It's important to the client, of course. It's important to you, but it really is not going to affect legal proceedings, who's cheating and who's not cheating, and what all that looks like. So that's good to keep in mind. We like to get that out of the way. It's good to set realistic expectations at the very beginning of how this is going to go, what to expect, what's going to affect this process, and what's not going to affect the divorce process. The other reason fault doesn't come into play, the fact that your wife is cheating isn't going to really come into play, is because for that to come into play, we'd have to be at a trial. I'd have to be in front of a judge. There's no jury trials with divorces, so it's what's called a bench trial. So you go to the judge and you present all your evidence and they make a decision. Now in their decision, they could consider the fact that one of you is at fault, or at least you're claiming one of you is at fault, but it would have a very small impact. And your likelihood of being at a trial and having a judge decide things is very small. Really at that point, it's not what should be happening. We feel like we've sort of failed you in a way. You know, a good 98% of divorce cases are settled out of court. So the likelihood that fault's going to be an issue, and you can prove fault, and you're at a trial, and a judge is listening to all that, and a judge is going to take that into consideration. We would never get to that point in the first place, because everything's going to be done through a settlement agreement, and through a settlement agreement, your wife's not going to agree, probably not going to agree, to take less property or have some other sort of form of punishment in the settlement agreement because she was cheating, or allegedly she was cheating, or whatever it might have been. So that's another thing to keep in mind here as you're looking at this whole process and how things affect it. Now another question that'll come up is, so what's the process of this divorce? How long does it take? What's involved? What can I expect? What's the cost? The whole thing. So process, so a divorce with minor children, in any county, there's a 6-month waiting period. So you file, the 6 months starts running. That doesn't mean you wait 6 months and then you start working on things. You start working on things right away, and court dates start happening and things starts coming and going. But there is this 6-month waiting period sitting there. So if we get 4 months in and you've got everything agreed upon and we're basically done, we've signed a divorce judgment and everybody's agreed on everything, you can't necessarily get divorced yet at that point. The law says you're supposed to wait 6 months until it can be finalized. Now there's judges that'll do it a little sooner. There's exceptions that are allowed 4 or 5 months in, maybe at the very, very earliest. But basically there's a 6-month waiting period. So at the beginning, when we don't know how your divorce case is going to proceed, we don't know exactly what's going on, it's a 5 to 8 month process depending on what county you're in. It could be closer to the 5 month, it could be closer to the 8, it could take even longer depending on what the disagreements are and how the case is proceeding. But during that 6 months process or 8 months process, whatever it may end up being, you go to court every couple months is kind of the deal. So you're kind of checking in with the court every couple months. Each court date has a different purpose. Depending on the county that you're in, they have different purposes. But you're not going to see less than 2 or 3 court dates no matter what. So even if you're getting along, you have everything worked out right from the beginning, we're still doing these court hearings, checking in, updating the court on the status of things and where we are and where we're going. And we're still riding out that, 6-month waiting period. And that's kind of the process, what that looks like. And, there can be this idea of let's settle out of court. So you can do that, and you definitely would do that, but that's not to say you don't have to go to court, because a divorce, especially with children, you would go to court. There's going to be at least 2 to 3 court dates minimum. Now that doesn't mean you have to have the court decide anything, but it wouldn't be the same thing as saying we're going to get divorced and never have to go to court, because you actually would have to go to court a few times, and that's kind of what that plays like. So it's good to keep in mind that's kind of the process. That's what it looks like as an overview, and that's what you could expect. Now there's other issues, of course, with property that are worth discussing. So, one question would be, are there retirement accounts? So you're getting divorced, and let's say there's $100,000 in a 401k. that the husband has, and also the wife has a teacher's pension. So she's got a pension, old school, like defined benefit plan that are really not, hardly any of those around anymore. So there's a defined contribution plan, a 401k, and there's a defined benefit plan, a pension. So what do we do with those? So you're getting divorced, you've been married 20 years, basically you're dividing those half and half. So if there's $100,000 in the husband's 401k, you would divide that. We can do a court order. We don't have to cash it out. We don't have to take out a loan. We don't have to do any of that. We can take the $100,000. We can take 50, move it to the wife's name in the divorce case. Now she's got 50 grand in an IRA. You've got 50 in your 401k. Nobody's paid penalties or taxes or taken out loans or done anything. We're allowed to move the money. It's a rollover. It's just like how it would work if you left your employer, went to a new employer, you got to take your money with you. Same thing. You'd roll it over to an IRA. So we can move half your account, move it to your wife. Now she's got half, you've got half. Everybody's equal on that. Now as far as your wife's pension, this pension through the state, also divisible. It can be divided through the divorce case and probably would be. So what you would end up doing is you would get half of that pension and your wife would get half the pension. Now that doesn't mean you get the money now. Like you said, you're both in your mid-40s, nobody's retired right now. So you would get half the pension. It's done by a court order, it's done by paperwork, what's called a quadro, qualified domestic relations order. We do those along with the divorce case. And then at the end, you're set up in the pension fund as if you had worked there, basically. So if your wife has 15 years of service with the schools, it would kind of look like you had worked there and have about 7.5 years. That's how the numbers would look. You'd end up with that value. So then at retirement age, you could start drawing that pension. Your wife is doing whatever she's doing with her pension. She's not paying you the pension at retirement. The school, the Michigan school retirement system is actually paying you, and they're paying her, and it's kind of two separate things as if you'd been two different employees. So that's kind of, in general, that's what you could expect on retirement accounts and how all that looks and, what to expect with those. So another issue that will come up is vehicles, what to do with vehicles. Let's say you only have 2 automobiles. Your wife has one and it's a lease, but it's leased in your name and there's a couple years left on it. And then you have a car with a car payment, but the car loan's in your name. So your car, we're good. It's your car. You're on the car payment. You just would keep your car, go forward, go your separate ways. Your wife's lease is a little more of a concern because you're not really going to want her driving around in a car lease with your name on it for the next 2 years. So at that point, you'd look at, well, is there some way to get this lease into her name? Can she qualify for the lease, take over the payment, and pay it, and have you removed from the lease? Because ideally, that's what we'd want to see happen. So the lease has no value. She's just renting that vehicle, or in this case, the loan is in your name, so you're renting the vehicle. So it has no value on paper, it's just rent. Now your car might have some value. If if you have a $15,000 car and you owe $7,000 on it, you got $8,000 of equity, kind of like with houses, you have equity in it. Meaning you could sell it and you get some money after you paid off the loan. So you could owe your money you could owe your wife a little bit of money there. If you got $8,000 as the value in the equity in the car, maybe you owe her $4,000. Maybe it's less, maybe we work it out with other numbers in your divorce settlement, but it's something that's sitting there that does have some value. So then another question that would come up with 13 and 15-year-old children, 20-year marriages, is college savings. What goes on, with college savings account? You might have a 529 plan, you might have a whatever it might be. Those normally just stay the way they are. There's no reason to change any of that because you're getting divorced. You keep the money where it is, it stays put, nobody's cashing out, nobody's taking it, the kids aren't 18 yet and going to college yet. So you got the college savings sitting there. And then it's good to keep in mind that no one can require you to pay for college. There's no law in Michigan that you have to pay for your children to go to college. So there would be no agreement in a divorce case to have you contributing towards a college savings. There's going to be no judgment of divorce. There's not going to be a court order that says you have to pay money into a college savings account. That won't be the deal. Now you might have some side agreement. You and your wife, soon to be ex-wife, might be agreeing, okay, I'm going to save this much money a year for college, or I'm going to do whatever the plan is. But you wouldn't have that in a court order or a judgment of divorce, and you would not want that in your court order or judgment of divorce because you don't want to be ordered to do something that the judge could not have made you do. So in other words, I don't want to be in court and I'm being chased around and there's enforcement and I'm getting threatened with going to jail because I didn't save for college. I mean, that would be silly. So college savings, you usually kind of leave it off the table as far as your divorce discussions, unless there's 529 plans, college savings, money already sitting there, then you keep that probably just the way it is and go forward that way. And then another thing to look at here would be debts. What's going on with the debts? Are there student loans? Are there credit card debts? Are there personal loans? Whatever it might be. So, the breakdown on that, first of all, student loans normally are just going to go with whoever is on the student loan. They tend to be just in one person's name. They were for that person's education, and that person should pay them when they get divorced. That's pretty much universally what you'll see happen. There's not normally a lot of discussion about my wife's got these student loans and wants me to pay them after we're divorced. Most people know that kind of is their thing and that goes with them, really regardless of where the incomes are. And you're also looking at, with student loans, you're not usually going to see joint debt. It's very rare that somebody would take it and somehow combine it into a joint debt, and now I'm stuck paying part of the student loans for my wife because we did something to borrow it together. Normally it's her separate debt. They can't come after me for it, and we go our separate ways on that. Her student loan is her student loans, my student loans are my student loans, and you kind of go forward that way. But there certainly can be other debt. There could be credit card debt. There could be personal loans. With those, we need to look at, whose name is on those, first of all. Whose name is the loan in? Who borrowed the money? Who's the authorized user? Because we got to know who can Visa come after. Because we can have all the discussions we want in the divorce case, but at the end, if my name's on it, I got to assume I might be responsible. I have no protection here. If we have a joint credit card debt and it's not going to get paid off in the divorce, now I got to worry about Visa coming after me for it after we're divorced. So you want to be aware of those issues. We like to know what debt you have, whose name is on it, who's an authorized user, what it looks like, whether it's credit cards, personal loans, unsecured debt of any kind. Secured debt we're not usually as worried about. Secured meaning I borrowed money, bought a car, I got a car loan, or I took out a mortgage, bought a house. Those are secured debts. Those are different way of looking at different analysis, but that's in general what you're looking at. So then, from there, we get to where we're probably kind of concluding our meeting with you at this point and looking at, are there other questions, are there other things that come up? And there very well could be. There can be questions about attorney fees. A common question would be, well, of course they want to know what we charge and what that looks like, or they want to know, do I have to pay for my wife's attorney fees? So in our scenario here, husband's making $90 a year, wife's making $40. It's a little questionable whether he'd have to pay much in the way of her attorney fees. Probably something there. It's different than she's a stay-at-home mom and has no way to pay it. So in other words, under Michigan law, there is a law that says if you cannot afford the litigation, you can seek contribution from your spouse. Would that happen in a scenario where somebody's making 90 and somebody's making 40? It could. It wouldn't be a real strong case for it, but there's certainly something there. The husband's ability to pay attorney fees is certainly stronger than the wife's ability, but the wife does have her own income too. Attorney fees normally can just end up being a marital bill like everything else that you would have to pay. So meaning it just becomes a joint debt. We got to get this attorney paid, get her attorney paid, and get this thing over with is probably the best way to look at all that. But in general, that's kind of an overview on a typical scenario of what an interview with an attorney would look like for a divorce analysis. We'd run through, get whatever questions you have answered, and give you a sense of what you got here. We don't have all the answers at the beginning, of course. We don't have all the facts at the beginning, but we're going on what we know, and we try to answer it that way. So hopefully that helps.